number 58, the people of the state of New York versus Bradford L. Shanks. We'll wait one moment, counsel, until your colleagues have an opportunity to leave. Or stay.
Good afternoon. May it please the court. My name is Kathy Manley, representing appellate Bradford Shanks, and I'd like to reserve 2 minutes for rebuttal.
You have 2 minutes.
Thank you. This court should hold that the fundamental issue of right to counsel survives even a forfeiture of counsel, survives even a valid waiver of appeal.
Counsel, can we stop there? Because I know we're going to probably get into some of the merits, and I just want to talk about the waiver for a second. So at that proceeding, as I see it, there's new counsel at the plea. That counsel says, I've met with this defendant 19 times to discuss this resolution. The people want a waiver of a right to appeal. There are some other charges, I think relatively minor, right, that are also disposed of.
Very minor that were not.
But let's say we agree with you and it survives a waiver. And now the next case comes, a hypothetical. Next case comes and there's a serious assault charge out there. Separate. Same facts though as here. This trial happened, we get to a plea, the people offer a deal. You get what you would have gotten in this trial, same sentence, you plead to the assault, you waive your right to appeal. Can you make that deal?
I think you just have to look at this court's decision in Thomas and look at the colloquy on the waiver, regardless of the amount of consideration.
But is there any way you could waive the right to appeal in my hypothetical scenario?
Including the forfeiture of counsel?
Yes.
No, I think that forfeiture of counsel.
So you would preclude your client from ever being able to make that deal, which is I'll plead to a separate assault case with the with the verdict I have here, I'll get the same sentence I would have got for the verdict alone if I waive my right to appeal, but I can't do that.
If he did a valid waiver of appeal, he could do that, and he could do that deal. It's a totally different situation than we have, but
so
he could do that, but I think it still should not include the wholesale deprivation of the right to counsel.
So my point is, no matter what you allocated to in that plea, this forfeiture issue would survive on appeal.
Yes, the forfeiture issue should survive on appeal. There's somewhat of an appellate division split, although I think the trend is going in the direction of saying that it survives a valid waiver of appeal. We have a new case in People v. Best in the second department that said that, kind of undermining the former case, People v. Whitfield. And then in the third department in 2018, there was People v. Trapani that said outright deprivation of the right to counsel goes to the heart of the process and survives both a waiver of appeal and a plea. And in my case, they actually said, assuming without deciding that it does survive. In the first department, they said it survives a plea, and then the third department cited that in Trapani for support for it surviving a waiver also. The fourth department's the one that said it doesn't in People v. Richardson in 2019. And it said that it does survive a plea, but not a waiver of appeal. But that was a very different situation. We weren't dealing with wholesale deprivation of the right to counsel at trial. We were just dealing with the deprivation of counsel's assistance and
Do we have to answer this question if we decide the waiver is invalid anyway?
I think it's important to decide that question, and I also think the waiver is invalid, and maybe it's important.
But if we said the waiver is invalid, then the question is moot. Okay, so let's get to whether the waiver is invalid.
Okay.
Because of course the appellate division has decided, I believe, pre-Thomas.
Right, and but Thomas should apply because
Correct.
This is on direct appeal. So under Thomas, the waiver was invalid because there was no indication that any appellate rights remained at all. The written waiver was even worse because it said you're waiving any and all rights to appeal, and then it listed some of the rights waived, which included the right to poor person status and assigned counsel on appeal, and that's clearly overbroad and misrepresents the law. And In Thomas also, the majority said waivers of appeal only cover a narrow class of issues not forfeited by the plea, and here, there was no plea, so it purports to cover a lot more, and including the review of the entire trial, where he was forced to represent himself, and where there was insufficient evidence.
Counsel, let's move along to, did the trial court properly conclude that this defendant forfeited his right?
No, there was no record support for the kind of extreme, it's an extreme last resort, according to this case in People v. Smith. There was no way that it even came close to that. The Third Department quoted People v. Sloan, saying there was a persistent pattern of threatening, abusive, obstreperous, and uncooperative behavior with successive assigned counsel.
Is that as a matter of law or because of the facts in the record?
Well, there was no record support for what should be the standard here to go to that extreme, last resort of taking away somebody's...
So did the judge mischaracterize the record? Is that your position?
The judge did mischaracterize the record, yes, because he was saying that Mr. Shanks, that there was a long series of attorneys that Mr. Shanks was disrespectful to or abused or whatever he was saying, and that's not the case. The record shows that the first 4 attorneys left for completely different reasons, like clear reasons, like having a conflict with representing his wife in the past. There was another one, David Taylor, who did a lot of work in the case, who was in the hospital at the time trial was supposed to happen. And then there was another one who moved to Atlanta. And then there was another one who had a conflict also. So there was no indication that Mr. Shanks did anything to cause problems with those relationships with those attorneys. It was just the last 2, and they didn't rise to that level.
Can I ask you a question? Assuming that the waiver of appeal was invalid, do we need to reach the counsel question?
Well, yes, because it would
Why?
be, because the Third
Couldn't we
Department...
just send it back without reaching it?
I mean, the Third Department did uphold the forfeiture, so you can reach that issue, and it needs to be made clear that if you have problems communicating with 2 attorneys, and with...
Let me take you a step further. I understand what you're saying. Thank you. I just wanted to ask you just another area. There was also a motion to ask the judge to recuse himself. Is that correct?
Yeah, there were 2 motions for that.
Okay. Was there an unrecorded conference in this case?
Yes, so that goes to the judicial bias. Attorney David Taylor submitted an affidavit in support of his motion for recusal, which he filed. And that might have been why he didn't want to come back in the case, because that was denied. And anyway, so he said...
That's understandable, but okay.
In December 2015, there was this unrecorded conference where the district attorney had said he was preparing to move to dismiss the case. There wasn't enough evidence, and that's something that Mr. Taylor had pointed out to him with information from the IRS, that there were 2 tax returns filed and the taxes on that
And
income
what
were
did the
paid.
judge...
So he said he was going to dismiss, and the judge gave him arguments for continuing to prosecute the case.
All right, now when you say this, what's the basis for the substance of the unrecorded conference, your information?
It was David Taylor's affidavit, and the judge, when he...
All right, and let me ask the next question then. Was the defendant present for this unrecorded conference?
I don't believe he was. I don't know.
What's the
but-
basis for your belief there?
Well, just because defendants aren't usually present in conferences, I think it was in chambers.
So it wasn't quite often in criminal cases, I was a city court judge, you'd have conferences on sidebars and you'd ask the defendant to step up. It would be quite common.
I mean, I don't know for
You
sure
just
whether he
don't
was
know.
there or not.
All right. And at what point in the case's history did the unrecorded conference take place?
Well, it was the David Taylor, it was December 2015. David Taylor
When
was
did the trial start?
The trial started quite a while later.
Yeah, I thought it was in the spring, but you know better than I do.
2017, right?
Oh, that much
So
further.
I understand that the judge was frustrated that so much time had passed, but that wasn't the defendant's fault. These 2 attorneys that came in, that was towards the end of the process, shortly before trial. And it just, when the last attorney, Hartgen, wrote a letter listing some issues he had, and he included the word threats, but then the judge had a appearance where he said the prosecutor has to leave the room and we're going to talk about this. I want to learn more about these issues. There was no
So,
mention of threats. It was nothing serious. It was,
Well, let me ask this. If the waiver of appeal is invalid, what are you asking this court to do on defendant's bias claim?
well, I think that just as with the right to counsel, the issue of judicial bias, as it occurred here and in maybe other cases, should also survive, well, a waiver of appeal, where you're saying if the waiver of appeal is invalid, you don't necessarily have to reach that, but...
Wouldn't it all just go back?
So I think the issue of judicial bias could go back to the third department because they didn't rule on that, they didn't reach that, but they did reach the forfeiture of counsel issue.
I see. Thank you.
Thank you, counsel. Counsel?
Good afternoon. May it please the court, my name is Christopher James DeDonna, and I'm appearing on behalf of the people. It's the people's position that this matter, that the third department correctly affirmed that the waiver of appeal here was proper, that the defendant executed it voluntarily, knowingly, and intelligently. Further, it's also the people's position that there was no judicial bias. If you look at...
Counsel, can I stop you there for a
Yes.
second? I think you submitted a brief that only rested on waiver.
Yes.
So why haven't you forfeited your other arguments here?
Because it's
If the shoe
the
was on the other foot, wouldn't you be sitting here arguing that the defendant, having failed to raise something in a brief, had forfeited it?
Well, Your Honor, it's the people's position that the, yes, we did in our brief to this court note that, or chiefly argue that the waiver of appeal was valid, but then we're also saying that the decision rendered by the third department, which covered these other issues, also should be affirmed. So we indirectly were supporting that belief that the other issues here, the judicial bias, and then the forfeiture of the right to assign counsel were properly decided.
You know, it's unusual to get such a short brief on these issues.
I understand that, Your Honor. I wish I had written it myself.
I'm sorry?
I wish I had written it myself. I was not in the office at the time. Or I was in the office, but it was not my duty to write it at that time. So I understand your position.
Yeah, I see. It's difficult to give the people's arguments substance if they don't put substance to them when they present it to us.
I can't disagree with you, Your Honor.
Okay. Thank you.
If I can continue just to address some of the points that were raised by, I believe, Judge Garcia early on in the appellant's appearance. It was noted in the record that Mr. Shanks retained a counsel post-verdict, and that counsel, Randolph Scharf, met with him 19 separate times, and he discussed this potential resolution in the case, which also included the resolution of the post-verdict motions that were filed. And it's people's position that that conversation that took, those conversations that retained counsel that Mr. Shanks obtained, that he had an opportunity to understand what he was going to be given up. Now, I wasn't privy, nobody's privy to what exactly happened during those 19 separate engagements between retained counsel and Mr. Shanks, but it's people's position that when you take that in consideration, plus the discussion that's on the record, I believe it was in April of 2017, post-jury trial, post-verdict, and then the discussions that were had on the record concerning what's being given up and the benefit that was being received. It's people's position that Mr. Shanks voluntarily, knowingly, and intelligently waived whatever particular rights, including this right, one of the rights here that's been contested about his right to assign counsel.
Is it your understanding that an ineffective assistance of counsel claim survives an otherwise valid waiver, or no?
No, that would survive.
And ineffective assistance would. So why then wouldn't total deprivation of counsel also survive?
Well, because here, Your Honor, I think there's a public policy issue that exists. If we have a situation where an individual like Mr. Shanks here is provided with 6 assigned counsel, people from the local and area bar.
That's a different issue. I'm asking you to assume for a moment, let me give you a hypothetical instead of using the facts here.
Okay.
Suppose the trial judge had said, I'm refusing to appoint you counsel at all, ever. You're just going to have to try this case yourself. And then after that, he goes ahead and executes a valid waiver. He's been deprived trial counsel. There's no record basis for doing that at all. Does that survive?
Well, I think that's kind of an apples and oranges situation.
I'm just asking about that hypothetical. Let's assume it's a pineapple.
Okay, so you're saying that he is not provided any counsel whatsoever.
Until he gets to the plea and the waiver. So he's got counsel for the waiver and plea, but he does not have counsel for the trial. He's represented himself over his objection. Never had counsel, never been offered it, asked for it, told he can't have it. Does that survive?
I would say in that situation, yes.
Okay, and so what's different then? Why is this a pineapple instead of an apple?
So what's different here is that there's record basis to show that Mr. Shanks engaged in behavior that rendered a breakdown in the relationship, the attorney-client relationship, that prevented
So then
his assigned counsel.
you're not really resting on the waiver then. You're just arguing he was appropriately denied counsel because of the record. The waiver has nothing to do with it.
Well, okay, so to go back to the issue of the waiver, here, if he's going, he had retained counsel at the time that the waiver, he had retained counsel at the time that he executed the written waiver of appeal. It's the people's position that if he's going to execute that written waiver of appeal, he's being advised by his retained counsel of what he's going to give up, what issues he's going to lose, or rights he's going to be able to lose in exchange for the favorable plea that he received.
Right, but I think you agreed with me, and stop me if I'm wrong, that if that waiver was valid and was counseled, it still wouldn't reach a total deprivation of counsel in my pineapple example. Just as it wouldn't reach ineffective assistance.
So, I don't know how to respond to that, I'm sorry.
Well, let me go ahead and move on then.
Okay.
So let me ask this then.
Yes.
The way I understand your argument is, first off, the waiver of appeal was valid, right? And secondly, even though it's not briefed, you're saying that his conduct was so egregious that he, in essence, forfeited the right to counsel. Is that an accurate characterization?
Correct, Your Honor.
The cases that I look at on right to counsel, when it's forfeited, usually involve assault, sometimes assault on the attorney or a witness, something like that, spitting, threatening behavior, attacking the attorneys in a physical or almost always in some form of a physically threatening behavior. Disagreeing with counsel is not that, and hasn't been that. How does this fall within those spectrum of cases?
I think it falls into the spectrum of cases because 2 of the attorneys in particular, towards the end of, and just
right, the last 2. I think we'll all agree that the last 2, they left, they didn't want to represent him.
Well, he made threats of malpractice. I think that's far worse than being spit upon in this profession. I think that causes serious concerns for an attorney and a great deal of discomfort, and causes an attorney, starts to divide the attorney's loyalty between him or herself and then his or her client.
So you're saying the 2 that were identified are enough?
Yes, in conjunction with everything else that took place here. There were 2 additional attorneys, though it's kind of buried in the record. The first attorney, Ryan Myasek, he not only left because there was a conflict of interest, but because he could not work with the appellant here, Mr. Shanks, and that was noted in the record. And the appellant agreed with the judge, the trial court judge, that he couldn't communicate with him. So that was noted, I believe, on January 17th of 2017.
I thought they relieved the public defender's office for a conflict of interest.
Yeah, it was also that, but if you also look in the record, Your Honor, and to the court, it's also noted that Mr. Shanks agreed with the judge that he said he could not get along with Mr. Meyersack. Additionally, the other attorney referenced here, David Taylor, who is the second attorney who entered into this representation.
So, counsel, let me interrupt.
Yes.
When a defendant offers to the judge who's presiding that he can't get along with the lawyer, what's the trial judge's obligation to probe that a little bit and try to figure that out and maybe even help that along? I don't know. You tell me.
I think the trial judge is supposed to say, you know, you need to work with your assigned counsel or your retained counsel. It's in your best interest to do so. If you don't, you may end up like Mr. Shanks did in this situation, representing yourself. If you don't work with the professional in this situation and defer to his or
But the
her.
colloquy you're referring to occurred after that office had withdrawn, right? I mean, this is not contemporaneous with the representation, or did I misunderstand you?
No, so
This is years later, is it not?
This is, so a record of the breakdown of the issues between Mr. Shanks and his attorneys is noted on, I believe, January 17th, 2017. It was during that closed hearing between Mr. Shanks, his current attorney at that time, Lee Harge, and the defendant, where the judge breaks down all the different lawyers that Mr. Shanks had and why those attorneys were no longer representing him. And it was noted there, Your Honor, where Mr. Meyersack was saying that he couldn't, or the defendant couldn't communicate with the
So that's
with
the
Mr.
first
Meyersack.
one. I'm not so sure couldn't communicate gets you there, but let's say that's the first one. There's several others in between,
Yes.
and he seems to be communicating just fine, right?
Well, to a degree. It's also noted at that same hearing in January of 2017 that even David Taylor, who worked a lot with Mr. Shanks, when he was asked a second time to represent him, he refused to. He said, I don't want to work with him based on his behavior. It's a small legal community, not Siegel County, and the word spread like a wildfire that he wasn't someone that anybody could work with.
Thank you, counsel.
Thank you, Your Honor.
Counsel, your rebuttal?
Thank you. Yeah, first, I agree with Amici that the prosecution did waive all of the arguments that weren't raised in their brief, and all that they raised in their brief was the issue of forfeiture of counsel surviving a valid waiver of appeal. So I think that's the only issue they should be able to go forward with. But in any event, the forfeiture, there was no way that it rose to that level here. And the idea that threats of malpractice or filing, I think it was a complaint to the committee, the idea that that should result in forfeiture of the right to counsel is not something this court should endorse at all. That's a very...
We all have different experiences. You're practicing attorneys who work in cases where you're arraigning people and you go through it. Quite often people would come in and scream at you at one point in a proceeding, and next time they've calmed down, and that's a common occurrence. I think that all of us who've dealt in the criminal law on both sides of the V between you has experienced. I guess the question is what the pattern of behavior is over time.
Right, and this really, I don't think you can rely on what the judge said about what, I think the judge misrepresented this record as far as these attorneys, and there's nothing from Mr. Meyersack saying he had problems with Mr. Shanks, and nothing really from Mr. Shanks saying that. There was just the judge kind of maybe remembering that wrong a couple of years later, so I don't think we can really rely on that. And Mr. Taylor never said that he wasn't coming back based on Mr. Shanks' behavior. That's just not in the record, and that's not the case. And Mr. Shanks was surprised. He liked him.
No, one thing I'd asked you before is, if we say that the waiver of appeal was invalid, then is there any reason for us to address at all the counsel question?
Well, yes, because you mean the forfeiture issue?
Right.
Yes, because the third department decided it wrongly, and so.
I see.
Yeah,
I see.
Because they reached the issue.
they did reach the issue in
Right, I
about one
understand
sentence, but yes.
Yeah. Okay, thank you.
Thank you, counsel.
Thank you.